I am the provost of the Clearwater campus of St. Petersburg College. And on behalf of the college, I'd like to welcome you here this evening to the forum for candidates for the 6th Judicial Circuit Court bench. For those of you who are not familiar with the Clearwater campus, I'd like to share with you a few facts. We'll be the home of 9,000 students plus in a little less than 2 weeks, attending classes in a wide range of programs, from a very, very fine arts program and photography and a very fine theater program to such programs as engineering technology, sign language interpretation, a cache of computer programs, and of course our paralegal studies program. I'd like to thank David Clement and the Institute for Strategic Policy Studies for co-sponsoring this event this evening, and the Clearwater Bar Association for co-sponsoring it as well. And with that, I'd like to ask the president of the Clearwater Bar, Josh Chilson, to take over. Josh?
Thank you. Good evening. My name is Josh Chilson. I'm the president of the Clearwater Bar Association. We are, with almost 1,000 members, the largest and oldest bar association in North Pinellas County. I'd like to start off by thanking St. Petersburg College and their Institute for Strategic Policy Solutions for asking the Clearwater Bar Association to co-sponsor this event this evening. The Clearwater Bar Association has had a long history and a long, good working relationship with SPC that we've always found to be quite rewarding, including our long-standing People's Law School program, which we have been doing together for many years. It will be again this year in January. I would also like to thank the Tampa Bay Times for co-sponsoring this forum. We have appreciated the Times advertising our events over the years, including our People's Law School. I've had the privilege of speaking to Curtis Kruger, who is on the panel this evening, about a few news stories, and have always found his reporting to be fair and of top quality. An important part of the Clearwater Bar Association's mission is our service to the public. To that end, we have numerous programs that we put on for the public, including our student legal internship program for high school students, providing attorneys to the Self-Help Center with the Clerk of Court, and our partnerships with Bay Area Legal Services and Gulf Coast Legal Services, where we are able to reach the underserved at great not-for-profits like the Homeless Emergency Project, the Haven, the Hispanic Outreach Center, St. Vincent de Paul, and so many others. With our dedication to the public, it is our hope that this forum will help to educate you, the voting public, about the candidates, their experience, their credentials, in order to help you cast an educated ballot on August 26th. With that, it is my pleasure to introduce a person who is very important to both St. Petersburg College and the Clearwater Bar Association, Dr. Susan Demers. Dr. Demers is the Dean of SPC's College of Policy Ethics and Legal Studies. She was instrumental in starting SPC's paralegal program and gaining ABA accreditation for it, one of only 2,500 programs in the country to have earned that designation. She has also been a longtime member of the Clearwater Bar Association, including serving as our president in 2005 and a longtime member of our foundation's Board of Trustees. She is with us nearly every week at People's Law School and was instrumental in getting our student legal intern program off the ground. With that, Dr. Susan Demers.
Thanks, Josh. So this evening's program actually focuses on 5 elections. We have contested elections in 5 circuit court races. And the way this is going to work is we've divided them into Group 1 and Group 2 in the first hour. We'll take a brief break, and then the final 3 groups will come in and we'll ask questions. Before I begin, I want to introduce our panelists, Kurt Kruger from the St. Petersburg Times, and retired circuit judge Irene Sullivan. And they've prepared a list of questions to ask the candidates. And what the way it's going to work, candidates, is that we're going to go down the line, ask each of you to give a brief 2-minute opening for both groups. And then we'll focus on Group 1. We'll take questions from Mr. Kruger and Judge Sullivan for your group for about 20 minutes or so. We're going to split the program. Then we'll take Group 2. We'll do closing remarks. Everybody's listening to everybody else, so if you hear something that somebody else says that makes you think I would like to address that in your closing remarks, we'll do that. we'll adjourn this, and we'll do the whole thing all over again. So I have to warn you, those of you in the audience, though, that this is a really interesting kind of election. In 1968, Florida revised its constitution, and it took them an additional 4 years to figure out the way they were going to structure the court system. In 1972, our new revised court system took over, and at that point in time, we settled on nonpartisan judicial races. And so there's some very limiting rules as to what our judicial candidates can speak on. They can't address topics on which they might rule, and they can't really actively engage in partisan politics. And so our opportunity this evening is not to hear their take on the issues, but instead an opportunity for them to give you their point of view and what they have to bring to service on the bench. And with that, I'm going to turn it over to our panel. Mr. Cooper.
Thank you. Well, let's start out with questions for Group 1.
Oh, actually, we're going to, sorry.
I'm sorry,
wrong.
excuse me. All right.
I'm wrong.
Okay.
I want opening statements. That's
Oh,
what
that's
I
what we
want.
want. All
Sorry.
right.
It's a good thing I'm not running for judge. I'm going to start with Ms. Snell at this end, and we'll do these opening statements, and we'll take it from there.
All right, I'll stand up so everyone can see me. Good evening, everyone. My name is Laura Snell, and I'm running for Circuit Court Judge in Group 1. I want to thank SPC and the Times and the Clearwater Bar for co-hosting this event to give us an opportunity to meet the voters. I am currently the Senior Assistant Public Defender of the Juvenile Division in Pinellas and Pasco counties, where I oversee 12 other lawyers. With 12 other lawyers in my division, we represent children who have been charged as adults, children who have been charged with delinquency matters, and also children who have been abused, abandoned, or neglected by their caregivers and are the subject of an open dependency case. And that program is called the Crossover Program. I have been a crossover lawyer since 2008, representing the child's interest in the dependency case and also anything that they get arrested for. I'm also an adjunct professor of law at Stetson University College of Law, where I teach the Child Advocacy Clinic. So that's third-year law students who are trying to become advocates for children. I'm also proud to say that I'm the president of the Pinellas Pace Center for Girls, which is a public school for at-risk girls ages 18 to 17. I know that my time is running out here, but I wanted to let you know that I have a diverse background in the law. I have represented people in criminal court from misdemeanor to murders. I've also been in private practice where I represented individuals in family law, probate, and estate planning. I would urge you to go to my website, which is www.snellforjudge.com, and visit my Facebook page, and hopefully we can answer some of your questions during this forum. Thank you very much.
Good evening. My name is Susan St. John, and I am a candidate for Circuit Court Judge in Group 1. Right now, I am an assistant state attorney at the state attorney's office working for Mr. McCabe, where I've been for the past 10 years. I have handled numerous cases, over 100 trials, handling juvenile delinquency for the first 18 months I was in that position. During that 18 months in Unified Family Court, I tried 31 cases dealing with delinquent acts. Those are non-jury trials that are handled for juveniles. After that, I moved on to the misdemeanor court, where I was a supervisor, and then I moved on to adult felony cases. For the past 6 years at the state attorney's office, I've been the lead trial assistant for gang prosecution. What that means is, think of the most heinous, violent felony offenders in this community, and that is what I do all day, every day. In that last 6 years, I've tried 48 of those very violent cases to conviction. That's important. Mr. McCabe has kept me in that job for the last 6 years because if I don't get it right, if I get it wrong, someone very dangerous goes back it out in our community. I've tried murder cases, robbery, rape, home invasion, all the real violent stuff. I take pride in what I do as an assistant state attorney. That trial experience will translate very well onto the bench. Judges have to make very fast decisions during the course of a trial, and we need to keep appellate issues low. Trial experience matters in this case. there are two other things to consider aside from trial experience, and that is life experience and demeanor. I have life experience. My dedication to serving this community didn't start when I signed up at the Assistant State Attorney's Office. It started when I was 17, when I joined the United States Army and jumped out of perfectly good airplanes. I did that for 6 years because I believe in serving this country, much like I serve this community every day. I have 10 seconds left. I'll stay and answer questions afterwards. I have a family. I have a 20-year-old disabled son. He's autistic and nonverbal. He's the best thing I ever did. That has made me very patient. Thank you for your time.
Mr. Rosenthall?
Good evening. How y'all doing tonight? You can come on, interact with me. I'm up here, you're down there. It's all right, doesn't matter. I'd come down there if I could. Here's the deal. I love the law. I love what I do. I love interacting with people. I love interacting with the community. That's why I want to be a judge. I've been doing this now going on 17 years. Out of law school, straight out of law school, I opened my own law firm. I enjoy it. I enjoy the law. I enjoy the intellectual stimulus I get from it. If you take an opportunity, before I think you may have my resume, I've got a very eclectic background. I'm the last of the Renaissance men, as my friends like to call me. I've practiced criminal law, probate law, civil law. A majority of my practice, though, is family law, and I've been doing that now going on 17 years, and I absolutely love it because it is probably the most personal type of law a lawyer can practice. Because it deals with you as an individual and your families. And over 17 years almost, I have now developed a very thick skin and a demeanor to understand what can happen to you and how to deal with people in those situations. And I think that's important. Demeanor is absolutely important. I've been married now going on 19, actually it is 19 years, as of the 23rd of this July, it was 19 years. I have 2 wonderful children. My children are in public school here. I hold a couple degrees. I'm kind of unique in that regard. I went to, started off as a bassoonist at the Loyola University. I was the principal bassoonist for Loyola, as well as a jazz saxophonist. Transferred to the University of Florida. I got a degree in a Bachelor of Science in Telecommunication, a minor in Music Education and Performance, as well as a business concentration. Extracurricular, I believe in doing as much as you can on this earth because there's so many good things to do. You gotta have fun out there, folks. I'm an avid woodworker. I hold 4th degree black belt in Taekwondo, a red sash in Wing Chun Kung Fu. I'm an honorary Godan and Goju-Ryu, and I get to teach on Saturdays when I'm not campaigning. I love it. Look, I can't tell you anymore. I'm out of time, but www.rosenthallforjudge.com. I'm here to answer your questions. Thank you for your time. I appreciate it, and I appreciate your vote on August 26th. Thank you.
Mr. Lark?
Hi, thanks for coming out tonight. I'm Ken Lark. I'm running in Group 2, and I think you'll find as you listen to everybody tonight here that we all kind of come from different backgrounds. I was first a paramedic and an RN, worked emergency rooms, actually did home health as well, and you'd like to say, well, why would you then become a lawyer, which I've been now for almost 18 years. But it's one of those things that I learned, and the things I've done in life is that it's actually about the people part of it that intrigues me and makes me think and tick. And so what I did was in 96, I graduated from law school at Florida State, and came back down here, and actually I should back up a little bit. I came here in 83 as a nurse. And for 30 years I've been living here in this community, and I've been a lawyer since 96, now about 18 years. And what I've done since that time is I've been a mediator for 9 years, worked in civil cases, family law cases for about 5 years, and also as a hearing officer for the St. Pete Housing Authority. That's a volunteer hearing officer where you actually do some of the things that I think are important to what you're looking for judges on the bench, and that is to spend the time to draw out information and facts, apply law to that situation, make decisions, and then write opinions that people can believe in and count on. And that's what I think is most intriguing about being a judge, and that is to make sure that the people respect what has happened in the courtroom, because if we don't have respect for what happened in the courtroom, then people don't live up to the obligations or results that come out of that courtroom. And I think that's key to what the judge has got to make sure happens. And that's what I intend to do, and I think it all starts with understanding people and understanding people's situations. I can tell you more about myself after tonight. You can Google my name, Ken Lark, circuit judge, and you'll sure find some information about me, YouTube videos and whatnot. My time's up. Thank you very much. Ken Lark.
And finally, Ms. Polk.
Hello, everyone. My name is Alicia Polk. I'm running for Circuit Court Judge Group 2. I am from a small town called Dade City, and that's in Pasco County, Florida. Has anyone ever heard of Dade City? It's a beautiful town. You should come visit it. I did not think so when I was 18 years old, stomped my way out of there up to Florida State, the furthest I could get, and still keep in-state tuition. But what I did learn when I got up to Tallahassee is that I missed my family and I missed my community. My favorite day of the week is Monday. Why? That's family dinner night. And every Monday night, I spend it with my 2 boys and my husband, my mom, my dad, my brothers and their families, my Grammy and my papa, and any aunts and uncles that can come that night. I love my family, I love my community, and that's what I'm doing here. I'm trying to serve the community again. I'm a former prosecutor. I now am in a private practice. We do a very general practice. We do family law, lots and lots of family law. We do civil litigation, represent a bank, represent a car dealership. We do guardianship and probate. We do dependency. We do domestic violence injunctions. We do criminal defense. I have litigation experience in every single courtroom I could be assigned to as a circuit court judge. What does that mean? That means I've been applying the facts of a case to the rule of the law for 11 years. And actually longer than that, because I was fortunate enough to be a certified legal intern and prosecuted before I actually had my license in Florida. So there's a lot more to know about me. I'll tell you real quick about my 2 children. I have 2 boys, beautiful, perfect to me, that were both born with challenges. And I can tell you that has opened up my door and my life experience to several different things I thought I would never have to be exposed to, but I'm grateful that I am, because it not only has opened my door to the medical field, it's also taught me to put things into perspective. And when you're showing up to All Children's Hospital to pick up hearing aids for your oldest and another specialist for your youngest, and you're seeing a kid sitting there waiting for a heart transplant, we're good. Keep it in perspective. And that's what I plan to do on the bench. Thank you very much. Alicia Polk.
Thank you. So now we'll move to questions from the panel. I want to remind the panelists that your answers should stay within 2 minutes. And audience members, we're not taking questions from the audience simply because there's so much to cram into this very short period of time. So with that, Mr. Kruger.
All right, for Ms. Snell and then for Ms. St. John. Judicial temperament. The term judicial temperament is often used in reference to a candidate's suitability for the bench. The American Bar Association lists 8 essential qualities for appropriate judicial temperament. Do you know what they are? What evidence can you offer as to your having the appropriate judicial temperament to be a judge?
Am I going first?
Yes,
Okay.
please.
Well, to me, judicial temperament is the way that a judge treats you. It's the judge's personality on the bench. And you would want a judge that will treat everybody equally. I look at the law, I look at the Constitution, brought a copy with me, as the great equalizer. It does not matter how old you are, how young you are, how much money you have or don't have. The law treats everybody the same, and the judge should treat everybody the same with compassion and kindness, and be stern when appropriate. I do not know what the ABA definition is. I have not looked that up. But I have been very involved with the Florida Bar and also the Clearwater Bar. I've been a member of the Clearwater Bar most of my career, and I think that's important to be a member of a voluntary bar association as well as the Florida Bar Association, because you're helping to improve the legal profession as a lawyer. So with the Florida Bar, I've served on 2 different committees. I've served on the Juvenile Rules Committee for a 3-year term, and I currently serve on a 6th Circuit Grievance Committee, which reviews lawyers' actions when people from the public or other lawyers or judges have concerns about their ethics. And so I sit on that committee and review those to make sure that the legal profession is upheld to the highest standard. And that ties into judicial temperament, because the judge is the forefront of the legal profession. And we want judges on the bench that can uphold that as well.
And Ms. St. John?
Okay, thank you. Get this a little closer. When looking at judicial temperament, I think the best indicator, I think we all know, of future performance is past performance. One of the things that I think I can bring to the bench is judicial temperament. I've had quite a bit of experience, obviously, doing gang prosecution. You meet a lot of people that are in the victims of very violent crimes. I go to their homes and I speak with them. I do that after hours because a lot of people have trouble getting out to the state attorney's office to meet during work. So I make it convenient for them. That's not part of my job. I do that because I think it's appropriate and I think they need to understand what's happening and it makes them feel better. That's part of judicial temperament. You need to be patient with people. When people come to court, they're not coming to court for tea. They're coming to court because they're getting a divorce. They're the victim of a crime. They're a defendant to a crime. They're having some complex, life-changing litigation. And people need to be patient with that, and they need to keep things in perspective. Judges need to be able to be patient with folks that are coming to court, especially pro se defendants, who I've had experience with extensively over the past 10 years. They come to court, they feel like they're being grieved in some way, they want resolutions, they want answers, and they need to know they're going to get treated fairly. I've had experience in the courtroom. I've also had experience outside the courtroom. I think being a mom has given me an enormous amount of patience. It took me 16 years to teach my son how to put his shoes on by himself. If anyone out here has ever been a full-time caregiver to somebody with a disability or has an aging parent, you know how important patience is. I can bring that to the bench. Thank you.
Judge Sullivan, do you have questions for the panel?
Yes, I do. My question will be addressed first to Ms. St. John and then to Ms. Snell. So, Ms. St. John, what's the most important thing you learned about law after law school? And how would that lesson help you as a judge?
That's a good question. I think when I graduated from Stetson, and I always thought that the trial advocacy class in Stetson did a fantastic job at getting us ready for actual courtroom experience. My first trial, I went in, and it was exactly like they taught me at Stetson, and it was wonderful. What they didn't teach you at Stetson was, how do you get people to actually show up? How do you get people to talk to you and tell you? How do you get an 8-year-old to talk to you about a very violent sexual experience that happened to them? And that takes a lot of time of dealing with people who are having extremely emotional situations. You're asking small children to get up in front of a room full of strangers and talk about the most violent, heinous thing that ever happened to them before. And you have to try and make them feel comfortable doing it. It's very hard. It takes a certain personality to do it. Not everybody can. But it takes a bit to get the hang of it, is dealing with people and trauma and not wanting to come to court and dealing with difficult situations. It's really the people aspect of it, I think, that I had to learn about the law, about explaining the law to people and dealing with the emotional part, that not so much the in and outs of the courtroom and explaining law to people, but the emotional part. People are charged when they get there, and they want somebody to talk to, a lawyer to talk to, who can hold their hand and explain it to them. So I think the patience aspect and the people part of it is really the important part that I've learned since then. Thank you.
Thank you. Ms. Snell, I'll just repeat it again. What's the most important thing you learned about law after law school, and how would this lesson help you as a judge?
Well, I also believe that having interaction with people is not something that can be taught. You can go to school and understand the law, you can have rote memorization and know certain things, but nobody can teach you people skills. And I started my career at the Public Defender's Office, where I represented individuals. And the first thing that I learned when I represented individuals in misdemeanor court, which are minor crimes, was that I was dealing with a lot of mental health issues that I was not prepared for. Nothing in law school prepared me to deal with somebody who was psychotic. Nothing in law school prepared me to deal with somebody who was extremely mentally ill to the point where they needed to go to the state hospital. And my background was, I have a degree in Spanish and a degree in international relations and comparative governments. So nowhere in there was a psychology background. I think about 2 weeks into the job, I went on Amazon.com and ordered an abnormal psychology book so that I could understand what these terms were, what the medications were, and I could be a better advocate for my client, so I could find out what they were going through and how to communicate with the doctors and the specialists. And so I have, as an adjunct professor, every time I go to Stetson and meet with the deans there, I say, you really ought to have a clinic or a symposium on mental health and a component, especially for people who are going into criminal law, because that is such an underlying issue that we see in the court system.
Thank you.
Mr. Kruger?
All right, and starting with Ms. Snell, what qualities have you seen in other lawyers who became good judges?
I think that there are some universal truths with good lawyers and good judges, and they are good people. Once you put on a robe, you don't change who you are. You're the same person that you were when you were a lawyer. And I believe that the people who make the best judges and the people who make the best lawyers are people who have integrity, who are involved in the community, who care about their neighbor, who uphold standards that society supports. And so I've seen judges who have come from both private practice that I've known through my work with the Clearwater Bar Association, and also judges who have come from the Public Defender's Office that I've called coworkers that I admire because I know their strong work ethic and I know how involved they've been.
And Ms. St. John?
Working at the state attorney's office, I've had the benefit of seeing many of the folks out of the state and public defender's office move on to the bench. A couple folks in particular, Judge Chris Hellinger was with the public defender's office for 20 years. She tried many, many serious cases. She understands the rules of evidence, which I think is incredibly important. She's been a fantastic judge to practice in front of. Not to say we always agree. I advocate for the state, obviously, but she works really hard to get it right, and she knows the rules, and she can do it quickly and efficiently. So I've always appreciated practicing in front of her. Judge Ballone and Judge Covert came from the state attorney's office, and I was in the office when they were there, and I've got to watch them. Judge Ballone was on our jury instruction committee for the Supreme Court. He knows it inside and out, and it's been fantastic to practice in front of him. Not to say I always agree with everything he does, but he works hard to get it right, and I certainly appreciate his attention to detail, the fact that he knows the law inside and out, and if he doesn't know it, he knows where to find it. So I think trial experience has been very important for me as a trial lawyer to see judges on the bench who can do that. And obviously being a people person is important, obviously. You're dealing with all types of lawyers and all types of people, but trial experience, life experience, and the appropriate courtroom demeanor, I think, are the three most important things. But trial experience is top on my list. Having tried over 100 cases, I need somebody on the bench who knows what I'm talking about when I'm talking about hearsay and jury instructions and striking panels and things of that nature.
Thank you. Judge Sullivan?
Yes, this is for Ms. St. John, and you just mentioned evidence.
Yes.
And of course, the knowledge of evidentiary law is crucial for judicial competence. So can you please give a definition of the law of evidence in a sentence or two, and then discuss your understanding of it and competence in it?
Okay. Evidence is what comes in and what stays out. I mean, that's the long and short of it, okay? Someone wants to say something while they're testifying and you hear an objection. It's either hearsay or something. And what's the second half of your question, Judge Sullivan?
Oh,
please?
and discuss your understanding of and competence in it.
Okay. Over 100 trials. I've had 31 non-jury trials, and the remainder, over 100 trials I've had have been jury trials at the highest level you can have in the criminal court complex, murder cases. Sometimes these cases hinge on one or two pieces of evidence, whether a statement comes in, a photograph comes in, whether someone's allowed to testify, and we are planning and strategizing that the judge is going to get it right. We need the judge to understand the law and get it right for justice to prevail. So it's important that judges understand those rules, and the best way to know those rules is to actually get in there and practice it. And I've been doing that for well over 10 years on a very high level, a very important level. Evidence is the single most important thing that happens during the course of a trial, and the evidence code is the single most important thing a judge can know when on the bench. And not just know it, but inside and out like the back of your hand.
Okay, Ms. Snell?
As was stated, evidence is what comes into trial, but a lot of people think that evidence is just physical evidence, a photograph, a fingerprint, things like that. But evidence can also be testimonial in nature, what people say on the stand. And as an advocate for children, I have to explain sometimes to 12-year-olds what it means to go to trial, and to be knowledgeable in the system, you have to try explaining it to a child who has special needs. So to take complex legal issues and explain it to somebody on their level, I think is a special gift and takes a special type of advocate. So evidence is what comes in at trial. It can be physical evidence, it can be testimonial nature or talking in nature. And the judge needs to understand what the arguments are for both sides, why it should come in or why it shouldn't come in. And that's where advocacy plays a role. Each side has an argument to make, and the judge has to make the ultimate decision as to what comes in and what doesn't come in. And those decisions are very important for the litigants in the courtroom. I also have a lengthy trial experience, having worked at the Public Defender's Office for over 8 years, going on 9 years. I have tried 25 jury trials, 10 as first chair, and also over 50 non-jury trials in the delinquency system. So being a public defender and representing individuals every day in the courtroom also gives me trial experience to understand that would translate well on the bench.
Thank you.
Mr. Kruger?
And starting with Ms. Snell, judges need to be careful, meticulous, and thoughtful, but they often have full calendars with cases that demand quick decisions. So how would you keep your cases moving, but still give them the time they deserve?
Well, I think that's an excellent question, and actually more an observation of the times that we have. I've heard estimates that each docket or each division has over 1,800 cases in them. And as an assistant public defender, I have sat in what are sometimes called mass dockets or calendars, where you have 50 people in one morning, and you've got to get that through in a 3-hour period. So as an advocate, I have made sure that my clients have their moment, and I have seen judges very effectively handle a mass amount of people to make sure they have their time in court. That can be effectively done in a few different ways. One is in dependency court, we use magistrates to hear things that can be approved, that don't have controversy. Both sides agree, we're here for a quick hearing, we can move through, and if there is an issue of controversy that needs to be heard in front of a judge, we can calendar that for the appropriate amount of time so that justice isn't just rolled through, that the parties actually have the calendar time to be heard. Another way that we can improve on that is by using technology. We have recently, within the last 4 weeks, switched over from the Computer Justice Information System to Odyssey, which in hopes of streamlining the process, going paperless in the future, and continuing things so that information is more readily available to the court, so we're not digging through files, and we can move through things with more efficiency and give people more courtroom time.
And Ms. St. John?
Repeat the question, please.
Sure. Judges need to be careful, meticulous, and thoughtful, but they often have full calendars with cases that demand quick decisions. How would you keep your cases moving, but still give them the time they deserve?
At the state attorney's office at one point, before I went into special prosecution, I was what was called a line attorney. So you get a little bit of everything working at the state attorney's office before you go into special prosecution. And at one point, I had 320 cases assigned to me at any given time, and that went on for several years. Right now, I manage a caseload of about 120, about 100 to 120, but they tend to be a little more work-intensive because of the severity of the charge. I have a lot of experience and have had a lot of experience over the past nearly 11 years handling a very, very high caseload where I have to pick and choose what I'm going to work on, make sure I'm managing my time effectively so I'm prepared for court. I intend to translate that to work ethic on the bench as well. If I have to work on the weekend, I work on the weekend. And when I was being interviewed with the St. Pete Times, I know they were asking me about that, and I told them that last year I tried, 12 cases, 10 cases, whatever it was, and for the first 6 months of last year, there wasn't a weekend that I didn't work unless I went out of town. I will do that. I will continue to do that if things need to get done. One of the biggest complaints about lawyers as we've been traveling the campaign circuit is make a decision. If you have to write an order, write your order, get it done so the litigants can move on with their lives. If I have to write my orders on the weekend, I will do that. I'm not afraid of hard work. I never have been. I will continue the same work ethic I always have. Thank you.
Thank you. So you've heard from the candidates from Group 1. Now we're going to shift over and ask questions. So Judge Sullivan, if you have a question for the candidates from Group 2, starting with Mr. Rosenthall, I think is the protocol decided on before we began.
All right, thank you. Mr. Rosenthal, describe your community service work, not just your pro bono legal work, but any type of volunteering you have done in your neighborhood, schools, religious organizations, or other groups.
Okay. Yeah, I think that's important for people to know how involved you're in your community. Let's see. I started off community service as a Cub Scout, and I'll work way up, I promise. I was a police explorer as a youth. I've been raising money for leukemia, cancer, heart research. I've been a part of the Masonic Order and the Shriners organization with the Shriners hospitals, the orthopedic centers, and the burn centers. They raise over $2 million a day for children. I'm heavily involved in those organizations. I am the legal advisor to the Grand Chapter of the Order of the Eastern Star, as well as the state chairman for legal affairs, which means my job is to oversee 45,000 men in the Masonic fraternity and their conduct, and when they go wrong, it's my obligation to make sure they have equal justice. It's hard enough to judge an individual that you don't know. It's about 50,000 times harder to do it to somebody that you do know, because those brothers are looking at you to make sure that they're getting an equal and fair shake. As you heard earlier, I hold a couple different degrees in martial arts. I've had the opportunity and I enjoy teaching on the weekends. Unfortunately, the campaign trail has taken me a little away from it, but I enjoy teaching self-defense to women and children. I get to do that a lot. I've been involved in the Cub Scouts and the Boy Scouts, as well as some other appendant bodies of the Masonic Order, including the Rainbow Girls and the Job's Daughters. The youth is our future. We cannot neglect them. So I'm instrumental in that. So that's all I have to say about that.
Okay. Mr. Lark, it's community service, pro bono work, all the activities you're involved in like that.
Thank you. You know, maybe I should talk a little bit about the past. You know, when I started off as a ski patroller and then went into EMS, and those were volunteer type things I did up in Vermont. As you can imagine, there's no skiing down here. But, and I thought that I had a life fulfillment and already had done everything I could do for a community. I thought I had already obtained all that. And when I came to Florida, you know, I started working in emergency rooms, and, you know, that's not exactly pro bono volunteer type things. But again, I kind of thought that I had met all my requirements for a community from what I'd already done in my earlier life. But I realized that really wasn't really enough. You feel actually your tank gets a little bit low if you're not giving back. And when I became a lawyer, I did start getting involved with things such as at Bayfront Medical Center. I'm on their institutional review board. I've been doing that for 9 years. What we do there is we actually oversee clinical studies on a monthly basis. I go there and participate in that. We make decisions about whether certain clinical studies will be approved and overseen. I'm also on the community law program as a trustee. I've been there for a couple of years now. I also provide free legal service there as well. Received last year for my efforts one of the pro bono pins that they award through the, I think the Florida Bar does that. I've also been working on medical missions. I've been going out internationally doing that. I keep my nursing license active, actually, so it gives me a chance to sort of do that. And I'll tell you, that really does fill my tank. I've been involved with Law Fest, which is something that we do in South St. Pete. I've organized foreclosure forums in St. Petersburg for several years. I think that's a good start.
Thank you. Ms. Polk?
Hello again. Can you hear me? Is that better? I come from Pasco County. Everyone knows where Pasco County is, and I come from a family full of school teachers. So you name it, I volunteer for it, and I've been doing that since I was a child. Recently, though, I volunteer on the community campaign against human trafficking. I'm a certified speaker for their bureau, and I travel around raising awareness about human trafficking to the local groups and trying to get the awareness and the support for the larger charities out there. I also volunteer pro bono hours to assist with expunging the records of some of these survivors. The law changed in January 2014, and now the survivors, as long as they can prove through an affidavit and a petition that they were under the duress of trafficking when they were committing certain crimes, then all of those crimes can be expunged, which is quite different from what the law is without the human trafficking factor. So we're navigating our way through that, a team of attorneys. We are trying to get through that and help those survivors so they can move forward with their lives. I am the president of my son's PTO at Academy at the Farm, and we are responsible for raising $200,000 a year to keep that school at an A rating. I volunteer at my local dance studio, which is where I grew up dancing. I was classically trained there, and I teach classes there. I have fallen back on that since the campaign trail, but I still do it. I also do the Great American Teach-In for the high schools and the middle schools, and go and talk about being an attorney and what it is to enter into a lease and all sorts of things for the seniors in the high school also. I volunteer for the local elementary schools, although my children do not attend them. Like I said, I come from a family full of school teachers, and my brother and my sister-in-law are teachers there, so I volunteer for their festivities. I go and work whatever they need me to do. I volunteer with Big Sisters, Big Brothers. I'm out of time. So thank you for your time.
Okay, thank you.
Thank you. Mr. Kruger?
Okay, starting with Mr. Lark. It has come to our attention that attorneys can sometimes be contentious in arguing their cases. If elected, how would you deal with conflict between attorneys appearing before you?
You know, I think obviously when people are advocating for their client, sometimes they'll sort of maybe go past that line in the sand. We don't exactly always know when it happens until it's happened. And so, you know, lawyers sometimes do that with the best of intentions and it gets away from them. And so I think it kind of depends on what's going on the bench, you know, when you're observing this on the bench, how you're going to address it. You've always got to be thinking about all the people that are involved and when it's occurring. You know, if it's in front of a jury, you're going to be handling that a little bit differently because all eyes are going to be on you about how you're going to handle that situation and the cues. And then this is what happens in hearings and in trials is that everybody's looking to the judge for a cue about how they're going to behave, how they're thinking about the case. And so you've got to be really cautious about how you address it. And every situation is a little bit different. You know, if it's something happening in chambers, as between a couple of lawyers, maybe a court reporter, you're going to deal with that a lot differently in that situation. So it's really hard to give you a real specific answer. But when it gets to the question of whether they're violating some type of professional code or conduct that we have, you know, then, you know, comes to this question of whether you're going to be reporting them to somebody. But, you know, and again, it has to do with whether they're young lawyers or old lawyers, whether there's habits that they have or not. But I think really the bottom line would be is that when the lawyers come to appear in front of you, they better already know that they're going to be held to a certain standard before they get there. And that's what I would intend to make sure they're well aware of that so that conduct would happen less frequently, I would believe.
And Ms. Polk?
I'm a big believer in taking a break. I have two children, two brothers also, by the way, so we took breaks in my family a lot when we would get into heated arguments. I do lots of family law, as I earlier stated, and I think that family law tends to get very heated at times, for good reason. I mean, people's emotions and lives are being decided that day. Lots to do with their children is being decided that day. So there's lots of emotions flying around the courtroom. Attorneys tend to get a little vested in their arguments. I think that, and I've been in the courtroom when it's happened. I've been in the courtroom when another attorney has stood up and screamed, and you're going, oh, okay, we crossed the line. But the best thing I think to do is take a break. We're taking a 5-minute break. Both of you leave. Go to different corners, you know, separate them. If it becomes an issue, though, I do believe in taking the jury out, taking the parties out, and addressing the attorneys by themselves, because I believe that professionalism is of the utmost importance in a courtroom, and it hopefully would be in mine. And I would expect them to follow the rules ethically and professionally in my courtroom, and I would make sure they understood that before we brought everyone back in.
Thank you. Mr. Rosenthal?
Yeah, that's an exceptional question. First of all, a judge should be able to recognize in his own courtroom when things are going awry immediately. And I can tell you when I was a younger attorney, and I know some of the judges in here are looking at me because they know, I was quite rambunctious as a youth attorney. You get in there, especially, and Ken said it as well, you got to look, is the attorney older or younger? Does he know what he's doing? Or does she know what she's doing? Are they a repeat offender? And, I can tell you, I was practicing family law now going almost 17 years, and you do get invested in your clients because you want to make sure that their case is heard, and you can get upset. But it's up to the judge, because I can tell you I've been stopped many times before I get started, because a good judge will recognize where you're going. He'll recognize immediately, well, Mr. Rosenthall, you're getting a little upset here. You might want to calm down a little bit. Okay, seems reasonable. The timeout is a wonderful thing. I can tell you how many times I've sat in a courtroom where the attorneys have gotten a little bit excited, overexcited, and the judge has said, you know what, we're taking 5. And it doesn't take them real long to do that, and they'll get right up and walk out, and you're kind of looking there going, oops, we crossed the line. We're people. We're all people. We all make mistakes. And when you're dealing with these matters, when you're in the circuit court, these are they're the hardest cases. And that's why people get invested. But a good judge will recognize what's going on in his courtroom and will react before it becomes a problem. And that's what makes a good judge. So I think it's experience. I mean, I'm going on a lawyer now going on 17 years. It's kind of like a preacher telling you not to drink if he's never drunk. I'm kind of the preacher that's drunk a little bit. I've been there. You know what I mean? Yeah, I've got upset in the courtroom. Sure I have. But I can recognize behavior because I've been there. I've done that. So stop it before it starts. That's what I would say. Al Rosenthall, thank you.
Judge?
Yes, I'm going to address this question first to Ms. Polk, and I want to emphasize that indeed, that Dade City and Pasco County are in the 6th Judicial Circuit, right?
Absolutely.
Okay.
Yes.
So my question is, what are the greatest issues or challenges that the 6th Judicial Circuit, our circuit here, faces today, and how would you deal with those issues if you were on the bench?
Issues regarding people within or the system itself?
Just
or-
what you think the issues or challenges of our particular circuit, the 6th Circuit, are, and how you deal with them.
We're a very large circuit, and I feel like I'm crossing into a country sometimes when I'm going from one county to the next. But I do believe that our issues are kind of common in all. We have high dockets. We've got high caseloads. It's hard to get into a hearing. I think we've got a lot of mental health issues out there. I think you see a lot of it in the family law courtroom. There's no funding for it. So I think there are several issues. I'll take one at a time and see how far we get before my time comes up. But let's talk funding. Let's talk funding a little bit. So you get into a family law court, and in Pasco County, I hear it's a little different in Pinellas, but in Pasco County, you need a guardian ad litem appointed. No one's going to do it. There's no list, except now there is one. I'm on it. I volunteered to do the guardian ad litem, but people can't afford it, and kids need it. Kids need to have a voice in the courtroom in some of these very nasty cases. It's a necessity that we need to look for. It's also with the family law courts, I deal with a lot of pro se litigants. They don't have the money for an attorney. Bay Area Legal can't represent them unless certain criteria are met. That's a huge hurdle in our court system, and everyone should be getting a fair shake. And some people can't without an attorney, and they flounder without an attorney, and the judge isn't allowed to instruct them on the law. That's a hurdle. It's a big hurdle. Getting into the court system and to get a hearing is a huge hurdle. I tried to get a trial just today, and we're looking in February of next year for a 5-day trial on a family law matter. Civil department is not as difficult to get into, and of course with criminal we have speedy we can always talk about. But I think that our high dockets, our high caseload is working against us in that. We just need more judges. And I'm out of time. So those are the first two I'd like to address.
Thank you. Okay, Mr. Rosenthal, the same question. What are the greatest issues or challenges in the 6th Circuit, and how would you deal with those issues?
Well, I think one of the biggest challenges is such a diverse citizenship of people. We have many different groups of people that live in this area. I mean, we have extraordinarily difference in cultures, and you have to have a grasp on that. You have to have been out in the community. You can't just be in your own population and think that you can deal with that issue. There's many cultural differences that people have to recognize. You know, like Ms. Polk said, she's like, I feel like I'm going to a different country when I come over to Pinellas. She's right. It's different. It's okay, we're allowed to have differences. We celebrate our differences. That's what makes us the greatest country in the world, or a melting pot. But I think that's a huge challenge because you can't look at every situation the same way. The law has to be equally applied. Don't mistake that. But people have to understand what the law is, and they have to understand through a cultural way how the law is being presented to them in that regard. So I think the cultural diversity is a huge issue. But moreover, I think the most important issue would probably be court time. And I don't think anyone can argue that because I can tell you just trying to get court time is a hardship. And especially in family law, you tell your client, I know your child has been taken by the other spouse out of the state. I'm going to try to see if it's an emergency. And most of the time, unfortunately, it's not. There's a very high standard for what equates to an emergency. So you're waiting 3, 4, 5, 6, sometimes 8 months before you can get in a hearing. And it doesn't happen all the time, but it can happen. And if you fall into that trap, it's horrible. Court time is not. Time is such an important element in getting into court, and I think that's a huge problem. But I think the electronic filing, I think if you can run your docket, if you can put those Band-Aids on it, like these cattle calls we were talking about earlier, that's what I would do. I would try to have more Friday morning calendars. I'm going to run out of time in about 10 seconds, but I think it's just more about judicial economy and prioritizing your schedule. Thank you very much, Al Rosenthal.
Okay. Mr. Lark?
First off, I think our Sixth Circuit is actually one of the best ones that I practice in, and I've practiced in quite a few of them. And not saying that just to placate the citizens, but one of the things that I do think we could keep working on here, and I think one of the problems we're having is just like everybody else, is doing more with less. And I think what is creeping into the system are demands to be more efficient and letting go of being more effective. In other words, those are what are the issues that are always in tension, I think, in the court. And I think that if we're not careful, we may lose what it is that the court gets for its respect and dignity, and that's making sure that everybody gets a real opportunity to be heard, feel that they had that fair shake. I don't think our Sixth Circuit has gotten there to that point, but that's one of the things that concerns me with the direction of where we are. I think we could use some more support services at the courthouse so we could be a little more efficient. But other than that, I think we got a pretty good Sixth Circuit.
Thank you.
All right, so Mr. Kruger, and this will be our last question for this group of candidates, and then we'll go down the line and do a 1-minute summation for all 5 candidates. So, Mr. Kruger?
All right, starting with Mr. Rosenthal. Many lawyers have professional ratings with agencies such as Martindale-Hubbell. Do you have a rating with this or any other agency?
I have no idea. You know what my rating is? My clientele. That's how I judge my practice. I don't judge it on some artificial, candidly, rating that's given out by some group that only cares about if you call your buddies and your friends and you say, hey, do me a favor, call up and tell them how great I am. You want to know how well my practice is? Call the Florida Bar. Look at my discipline record. That's the rating I care about. You're not going to find a discipline record. You know why? Because my clients have got I have an excellent reputation in the community. I'm doing family law almost 17 years and not having a disciplinary record, not having any type of discipline against me or bar complaints, I think that says something about a man's character or an attorney's character, man or woman. I have no idea what my rating is. Did you look it up? I don't know. Once again, I don't really care. All you got to do is ask my clients, hey, how'd Mr. Rosenthal do on the case? He was awesome. Look, Google my name, please. Find something bad about me out there. You won't find it. You know why? Because it doesn't exist. That's the rating I care about. I care about the rating my client gives me because they're the one that directly interacted with me. And aren't they, of course, the best person to ask then? Some third party you can call up and say, hey, Joey, Steve, Bobby, call this AVO rating system and let them know how great I am. Your peers are important. And take a look at the list of my endorsements. Those are the things I care about. I care about what the people think, not some artificial firm that makes up their own rating system, because I know plenty of lawyers that aren't rated at all because they didn't take the time to call them up and even care. And you know what? I didn't do it, and I just didn't care that much, because what I care about, once again, is the community and the people that I've helped. And if they thought I did a bad job, you can guarantee it'd be on the internet everywhere. So I invite you to take a look, Google my name, and find bad stuff about me. And if you don't, on August 26th, bubble my name in, please. Al Rosenthall, thank you.
You know, I think Mr. Rosenthal makes a good comment there, and that is that, you know, there are businesses that are out there that will give ratings to professionals. Martindale-Hubbell, AVO is another one that's out there. And I think you have to really look at that and decide if there's value to that. I've found great rated lawyers and found subpar performance, and I think you know, I haven't personally gone to seek the Martindale-Hubbell rating. Partly, I think it was the way my practice developed. I started off doing medical malpractice originally, sort of a niche little area, you know, and because of that, you know, you deal with a very small circle of people that do that, somewhat boutique-ish. And because of that, you know, I just didn't really develop large circles to do the Martindale-Hubbell. People who knew me and litigated against me knew me and respected me for that. Also, with my nursing background, people liked the medical background that I had, the ability to apply that to the situation. I think that's also something that you find in the court system too, is it's helpful to have that mental health and substance abuse and medical issues that you find in a lot of the cases. And so I think that's really, to me, more valuable. Again, I think Mr. Rosenthal is right. Who endorses you, who's your supporters, are things to look at. You can find that on my website. There is an AVO thing for me. I'm not sure what its current one is, but I don't think it's terrible, though. But I think it's all right. And people come back to mediate cases with me, so I think they have some respect for me in the community. Thanks. I'm Ken Lark.
I'm going to have to agree. I can't believe we're all agreeing on the same thing here, but I don't know what my rating is, to be honest with you. I've never looked into it. I have gotten those emails that say, hey, come visit our site and invite 6 of your friends to join, and you know, your rating will start creeping up, and I'm headed to court. I don't have time for it, to be honest with you. I'm working. So, and that, not to say anything bad about people that do that. It's just a different priority in my life, and I'm a high litigation firm. I'm in court all the time, and I'd rather spend my off time with my kids than on the computer or calling friends to beg them to go to a computer, to get onto a website, to perhaps, I don't know, submit a comment or to click the 10 button if they think I'm great. Again, I have repeat clients. I have opposing parties come to me afterwards with their new divorce saying, can you please represent me? I want you to do what you did to me, to my next wife. That's always a great compliment. And one of the best ones is that I had an opposing party that keeps referring people to me. It's fantastic. He's the best referral source, and I practiced against him in court. But it's a good compliment. He thought I did a good job. He thought I was professional. So he sends all of his friends and his clients to me I thought it was awesome. I'd rather have that referral than a Martindale-Hubbell or an AVO rating, but I don't know what it is, to be quite frank.
All right, thank you. So now we're doing the lightning round. So what I'm going to do is I'm going to ask each of our candidates to take about a minute and sum up. So I'll begin with Ms. Snell.
Okay. Well, thank you all for holding out till the end here. Again, my name is Laura Snell, and I'd like to be your next circuit court judge in Group 1. Something that I haven't mentioned is important is my family history. You may recognize the name Snell. My great-grandfather and his brother developed St. Petersburg, Snell Isle. And so my family is known in this community. My family goes back generations, back to 1899 in Pinellas County. It's important to know that because it's not something I can just run and hide. People know the Snell name. And I've also been involved in this community. I've been a leader in this community. I've been a leader in the public defender's office as a senior assistant public defender. I've been a leader with the Florida Bar. I just graduated from the Florida Bar Leadership Academy, which is a year-long leadership program for lawyers. And I've also been a leader with the Pinellas Pace Center for Girl as the president of that board. I'm asking you for your vote on August 26th or by mail before, so please support Snell and vote for me. Thank you.
Susan St. John for Group 1. I'd like to thank everyone for coming out tonight. One of the things I didn't mention earlier I was in fact recommended by the St. Pete Times, or the Tampa Bay Times now, I have nostalgia for them, and the Tribune, and I think one of the things that really was important for me that I am happy the paper recognized is that I have trial experience and I have a depth of life experience. I spent a lot of time talking about my trial experience, but I cut the cord at 17. I am self-made. I put myself through school using the GI Bill. I raised my son. I know I look like I'm 15, but I'm really 40. I packed a lot of life into my 40 years, and that's going to aid me tremendously on the bench. So thank you for the newspapers for recognizing that, and I look forward to having your vote on August 26th. Thank you.
Well, good evening again. Once again, Al Rosenthall, Group 2. I've had a great time. I don't know if you did. I've had a great time. I do. I love this. This is great stuff. I want you to know I have substantial courtroom experience. Maybe you didn't read that in the paper. They didn't put it in there. But yeah, they didn't. Sorry. But I do. After 17 years of private practice, believe it or not, I've been in a courtroom once, twice, 3 times, well, a lot. I do trials almost every week. I don't do jury trials. I practice family law. We don't have juries. I'm sure that half of my clients on the other side are happy we don't have juries on those trials. But I manage a caseload of between 150 to 200 cases a year, and I've been doing it almost 17 years. And in family law, you're in court almost weekly. So do the math. I have substantial trial experience. I'm the only one at my firm that's a trial lawyer. So if there's a hearing, contested or otherwise, I'm the guy going down there and doing it. And I love doing trial work. You know, once again, check out my website, www.rosenthallforjudge.com. I've got a depth of experience inside and outside the law. I appreciate your time tonight. Alan Rosenthal, Group 2. Thank you.
Hello, Ken Lark again. A couple of points I'd probably like to bring out to you, and that is that, you know, I think that what's important is having some decision-making aspects in your life when you go to the bench versus just doing advocacy. And that's one of the things that I bring with my hearing officer experience. I've had over 100 evidentiary hearings in that respect. Also, I've been a mediator, which is a problem solver person, you know, and again, that's a neutral person, and you're trying to get things done. And again, that's different than advocacy. And I think all those things that I bring from my past medical experience are things of showing calmness and having the right demeanor when you're under pressure. And I think that's all that you want as people come to the courtroom, is somebody who's going to be calm, patient, listening, take in information, not get distracted with other issues, and be able to make a sound decision you all can live with. I'm endorsed by the PBA and also the Florida Nurses Association, and I think they recognize my calmness and my ability to perform, hopefully in the courtroom as a judge for you. I'm Ken Lark, Group 2. Thanks.
Alicia Polk, Group 2. I did want to bring out my endorsements. The Tampa Bay Times endorsed me, and so did the Tribune. The Tampa Bay Times did quite the background check, and still endorsed me. Fantastic. I've also been endorsed by the Fraternal Order of Police, Group or Lodge 10, Lodge 29, and Lodge 43, by Sheriff Gualtieri, and by Sheriff Chris Nacco, and by Clerk of the Court Paula O'Neill. I think what everyone should take away from this is that circuit court judge makes very tough decisions. They're talking about prison time. They're talking about life in prison. They're talking about taking away your kids, terminating your rights, taking away your property. These are heavy decisions. Who has the trial experience and the courtroom experience and has been exposed to these types of decision makings would be appropriate for this type of position? And I would submit that I have that experience. I've been arguing on both sides of all of those cases, and I hope that you consider me August 26th, Alicia Polk. Thank you.
All righty. Well, I want to thank this group of candidates, and if you can make your way safely off of this stage, we'll bring in the next group of candidates.